Taimur, thank you so much for your time. I'm grateful to be here with you to have a conversation about startups and innovation and intellectual property. Um, you are a startup and venture capital partner at Fenwick and West, a leading technology and life science focused law firm, and you're in Silicon Valley, right? So you're in the thick of it, and you're counseling the most innovative companies in the world on all types of corporate transactions. So I want to start by having you introduce yourself by sharing how did you become interested in startup and venture capital law, and what was your journey to Silicon Valley?
Yeah. Well, hello, and thank you for the warm introduction. As you mentioned, I'm Taimur. I'm a startup partner here at Fenwick, and I'm happy to be here talking to you as well about these things. Startup law is a really exciting area of practice. It is an area of practice in which I encounter lots of different kinds of people with lots of different kinds of ideas and products, and I think that's why it kind of lends itself to a conversation about IP, right? Because, and we'll get into that, I assume, but kind of those ideas, those products, and the differentiators and the things that make our clients exciting and excited, those are really the things that we think about when we talk about IP. So for me, the journey to this area of practice and to this geographic area probably started my journey to practicing law started a long time as a kid. I think I just had a bent for justice. I wanted things to be fair. I wanted to understand things. I wanted things to make sense. And I kind of required that. I think my brain needs that. It needs things to make sense. And so just having kind of a logical orientation growing up, and also being a bit expressive about that meant that adults and other people around me identified me as a lawyer before I was actually anywhere near becoming one. I also was interested in systems, and I really mean people systems, so government and political systems, things like that. And I was into the performing arts, so I grew up singing and doing theater. Um, and the practice of law, or what I thought of the practice of law, suggested to me that I could kind of marry the different interests that I had and the different ways in which my brain works into a career that would be fun and exciting. And at that time, I really thought I was going to go into entertainment law. That was kind of my dream. I wanted to work in the industry, but as an attorney. And so I went to college and I interned in entertainment. I spent a summer down in Burbank at Warner Brothers and loved that. I did some theater stuff in college. I studied music, but I also knew that I was on a trajectory to law school. After undergrad, I got a job at a big tech company called Google. And I, at that time, became kind of fascinated with the innovation that was taking place in the entertainment space. So the ways in which we consume and interact with media and entertainment platforms and how that was changing in real time all around us. So whereas growing up, I watched TV on the television exclusively and
Right.
had to, record things on a VCR if I missed them. And then the progression of that technology, and then to, services like Netflix, and then to services like Napster, LimeWire, which some folks
Yeah, a
won't
lot of folks
even,
aren't gonna know about.
yeah, they're not gonna know what I'm talking about.
Yeah.
And then by the time I got to Google, we had YouTube, we had Netflix had evolved a bit in its model. We had Pandora and Spotify. We had other platforms that were exploring this idea of putting original content online, which had not ever happened before. Right? And then we heard about deals being penned between YouTube and name your entertainment company to create content in a studio and put it online versus putting it on television or on the silver screen. So those things were really exciting to me. And I started to feel like the more interesting things that were happening in the industry were happening in Silicon Valley versus Hollywood. So that's kind of how I ended up deciding to pursue a career in the Valley, studying some IP in law school and things like that. Now, when I got into the actual study of law and practice of law, I learned that entertainment law is kind of just as much of a rat race as being an artist or anything else in the entertainment industry. So I thought being a lawyer would kind of get me a pass to a really exciting career or on a fast track the way it does in some other industries. But in that industry, you still kind of start in the mailroom, even if you have a fancy law degree. And I wasn't interested in doing that. And get that. Did you try it? Yeah, I wasn't really interested as interested in participating in that rat race because part of the reason I wanted to practice entertainment law was because I didn't feel like I had the ambition to be an artist professionally, right? So this was supposed to be my kind of practical, stable pathway into a career that was interesting. And anyway, I was just more interested in the things that were happening up here. So I decided to stay in the Bay Area and start my career here at Fenwick. I've been at the firm for a decade. I spent a summer here during law school, and then I came here to practice full time. And I've had the opportunity to work with incredible tech and life science companies that span all the industries, right? So, fintech, digital health, media, apparel, consumer, AI, SaaS, security, all kinds of different companies and products and founders. And it's been really cool.
Thank you for that. You mentioned that at Fenwick, you get to work with companies across all industries. And I'm also assuming that at Fenwick, you get to work with companies at all different stages of their maturity. So I definitely want to talk to you about IP, but I want to talk to you about IP within the context of your practice. So I'm curious, generally, what percentage of your clients are startups? However you define that. If you don't mind defining, what a startup
Yeah.
is first, and then what percentage of your clients are startups?
Yeah, for sure. So my practice is pretty exclusive to startup companies and investors investing into startups, and I'll define that a little bit. So at Fenwick, we use startup really to generally mean private companies. It's a little bit of a misnomer because they're kind of, there are really early stage companies, think founder, laptop garage, and a deck. And I also have clients that are super late stage, pre-exit, series E, F, G, H companies, right, with thousands of employees and a global presence. And we consider those startups too because they're private companies. They haven't gone public, and they haven't been acquired. And then I represent companies all between those different ends of the spectrum. But then I also have a meaningful investor side practice. So I represent VCs, corporate strategic investors, family offices, individuals investing into private companies as well. So my practice is probably about 80% company side and 20% investor side. Um, and that's a
Okay.
rough kind of estimation of the breakdown. And then within that 80% company side, um, maybe half are, or maybe half of my time is spent with earlier stage companies, call it series pre-seed through series B, and then the other half of my time is probably spent series C, D, E, F, G, H, I, companies or companies that are on the precipice of an IPO or being acquired by a later stage company or merging or something like that.
Okay. Incredible. Because I think that this lends itself to a perfect sort of case study on where IP comes in and why it's important at different stages of a company's growth. So I'm curious, let's talk about the company side first. Obviously, we know the people are really important at the early stage of a company. The
Yep.
product market fit is very important. The sort of business validation, the business model validation is very important. But to what extent, when you are speaking to early stage startups, so you said pre-seed to Series B, to
Yep.
what extent is their intellectual property story important when you're counseling them on different financing strategies? To what extent is their IP story important?
The way I think about IP is really broad, because IP, intellectual property, is a very broad concept, right? We're talking about kind of all of the ideas and creations and works that a person comes up with, or that a team or a company comes up with, whether, fixed on paper or not, or, in a product or not. We're talking about all the things that people contribute from their minds into the creation of a thing, right? And I think some folks think about IP more specifically in terms of the different categories of legal protection that are available for intellectual property, so patent, trademark, trade secrets, copyright, and everything outside of those formalistic systems. They don't necessarily think about as IP. But as a startup lawyer, I kind of think about all of it, right? Everything that you have as a founder, that you've built, that you've created, everything that you've discussed, designed, ideated, is your intellectual property, and it all has some value. Um, and I think it's really important for companies at early stages to have an IP story. Now, your IP strategy is distinct, I think, from your IP story, right? So you may not ever have filed anything with the U.S. Patent and Trademark Office. And you may not have any filed or registered IP, but you have IP. And it's important to protect the IP you have. It's important to get those NDAs signed when you can. It's important to, one area this comes up a lot, where this comes up a lot, is in the context of founders and ownership of a startup, right? So when founders get together and they're forming a company and they are deciding who owns how much of the company, it's important to understand people's IP contributions and to ensure that, we have buttoned those things up and that we are clear about who is contributing what to the business, and that we are compensating people for those things, and that we're getting paperwork that reflects those arrangements, right? And not to sound super lawyerly, but I think for early stage companies, that's something that your investors are going to care a lot about. So just as much as they care about the IP that is in the product, like as much as they care about your trademarks, your patents, whatever you have copyright protection of, the things that you own formally, they're going to also care about how you think about different individual people or service providers' contributions to your company, right, and to your business, and to ensure that you have been managing that properly all along, that it's clear who owns what, and that there aren't going to be questions down the road. So it's kind of a different way of thinking about IP. I think it's not super cool, and like fun and exciting in the way that some people, I think of IP. But as a startup lawyer, right, one of the most important relationships that we help founders think through is, what have your employees contributed to this product? And have you made clear
Yeah.
that the company owns those contributions? Have you made clear what contributions the company doesn't own, and who has the right to use it, and when, and for how long, and the circumstances around those contributions? Because when your investors come along, they're going to dig into all of that, and they're going to want to know that we've done the work to make sure that that's in order. And then, of course, there's the actual product, and there may be things that do require a more in-depth analysis or registration or thinking about your brand, right? So getting my founders on the phone with my trademark colleagues to have them run searches and make sure that the brand name that you plan to use for your big product or for your big launch isn't already being used in commerce by another business that's in the same space as you, right? So just thinking about things like that. Founders have really brilliant ideas for what they're going to call their company, what they're going to call their products, what they're going to look like. And it's a real big downer when you build this whole campaign and then you realize someone else actually has rights to the thing that you built, or there's something that looks or sounds or feels really similar to it, and that might open you up to potential IP exposure. So, or live, infringement exposure. So, those are kind of some of the things that we help early stage companies think about, and it's really important.
That was a great explanation on the distinction between an IP story versus an IP strategy. And also thinking about from a company perspective, the difference between sort of collective, sort of jointly creative intellectual property and sort of individual employee created intellectual property, and what needs to happen to be able to essentially assign, right, or transfer that IP over to the company so that you can look attractive to investors. So that's the company side, right? Um, Thinking from the venture capital side now, right? You said that's about 20% of your practice. Right? What are some specific things that they look for from an IP perspective? I know it probably depends on the specific industry, the specific product and service. Software is different than hardware. Um, a specific IP investment in a particular asset is very different than investing in a full company. But what do they generally look at, right, from an IP perspective that they want to see from an early stage company? Again, talking pre-seed to Series B.
Yeah. So pre-seed, to Series B, kind of early stage companies, it's a lot of the stuff, I think the technical stuff, right? So like I said, who is here? What have they built? What have they contributed? Some of the key questions will be things like, has everyone contributed their IP? If not, what have they excluded? Does the company need any of those things that have been excluded in order for their product to be successful, right? So if I'm an employee and I come to startup A to work, and startup A hires me because I have a lot of expertise in a particular area, developing a particular type of IP or contributing to a particular type of IP, maybe at a private company or my own company. And I come in and I build some things for startup A, but I never assign my IP to startup A, any of it. Then there's a question around whether startup A can actually has the right to continue to use the things that I've contributed if I decide that I'm going to leave startup A, or if I no longer want startup A to use those things, right? So an investor's going to ask, have you checked those boxes? Have you done what you need to do to make sure that my contributions to startup A actually are owned by startup A? Because the investor's thinking about 5 to 7 to 10 years down the line when the company's worth a whole lot of money because everything has been successful, they've been successful, or when we're approaching an exit and we have to make sure that, those things are clear, that the IP chain of title is established, it's well established, and it's clear, right? So have all of your employees and service providers signed up the right paperwork and done the assignment kind of thing. But every now and again, there are things that might be embedded in a company's product or that a company uses to build or develop its product that it doesn't actually have a right to use, right? Or that a right where a right can be revoked. And it doesn't mean that an investor is going to necessarily walk away or blow up the deal, but they'll want to understand, is that thing or those things necessary for this product to succeed? If we take out his contribution, does the product still work? Is it something that we can re-engineer? Is there a gap that we can fill? Is it a necessary element of the business or of the product? And if not, then it's probably okay, But if it is, then we have a big problem. We have a problem that we have to solve, a question that we have to answer. And so investors will care a lot about those things. They'll spend time, in diligence, kind of reviewing the company's records to make sure that they thought about those things and that they have answers for those things. Other elements that have come up in more recent years are, open source materials, how companies use open source materials. A lot of early stage companies don't necessarily track their use of open source materials and libraries, but investors will actually care about that. They want to know that you're not using things that will taint your product or your ability to sell or capitalize on your product, right? Because some open source software has stipulations, right? So you can only use it or embed it if you treat it a certain way, and you might not be able to monetize your product correctly or well if you have those software elements embedded in your product. Another area
Yep.
is the use of AI, right? That's obviously a hot button topic right now. Investors care about that. If you are in a regulated space, where you're collecting personally identifiable information, you're in the digital health space, you're, creating or building things that kind of rely on human data and especially identifiable human data. We want to understand how you're using, you know, um, AI products in either like in the development of your product or how those things are being embedded in your product and how your users are going to interface with them, right? Because anytime you're kind of introducing something that's newly regulated or in the process of being regulated or that people don't really understand that well, then it raises a bunch of questions, right? And there are certainly open questions right now about how the use of AI intersects with intellectual property, right? Who owns this stuff? When you put information into a GPT model or a platform, when you put information into, when you tell something to an AI agent, is it
Right.
protected? Whose is it? Who owns it? Or, and it's interesting because we encounter it all the time, even on Zooms and stuff, right? We have folks who bring AI bots into Zoom meetings, and when you're on the Zoom with your lawyer or your doctor, and it's a really cool thing that you have this AI enabled product that will like summarize or take notes or record, or the actual platform itself is something that a startup developed that allows you to tell it what your symptoms are, and maybe you get on with a doctor, right? Where does all of that go? Who owns that? What is that? Is that property? Whose property is it? And so there are all kinds of interesting AI and IP questions that come up for investors in the process of investing in early stage companies. And the idea is that founders have good answers for these questions and have good hygiene around their management of IP.
So I want to just dig in a little bit deeper on the AI piece because we know that that is obviously those are tools that startups are going to be using, right? If you're
Yep.
trying to make an innovative tool, I think speed and velocity really matters right now because a lot of your competitors in the marketplace, they're using the AI tools. So if we're thinking that AI is inevitable, right, in some sort of vertical of a business to be able to create an innovation in 2025, how do you navigate, right, making sure that your IP is defensible so that it can ultimately be bankable when a VC comes and wants to give you money while also using these AI tools?
Yeah, I think it requires all of us to be really careful, right? When we're putting information into the tools, being mindful of what information we're sharing. Just like when we walk into a meeting with a human being to share, what we're building, and we are circumspect about how much of it we share, what elements of it we share. It's kind of the same thing, right? It's not um, there's no one for you to hand an NDA when you are using an AI
Right.
model, right? But that's kind of the mindset that I like to have, even in our practice, right? We create things all the time in the practice of law. We write things, we draft things, we prepare things, we revise things, we think through things, and we write memos or whatever it is that we produce. And that's intellectual property. There's an additional layer for us because we have to think about privilege, right? And how there's just a level of confidentiality that we have to observe, and a way in which we have to protect our clients. And so that's not necessarily the case for everyone else who's building things or creating things, but the principle kind of remains the same. you have to assume that when you put your information into a platform, that it goes somewhere and you don't know where that is and you don't know who has access to it on the other side, right? And in many instances, you're actually feeding the model so that it can produce information and responses to other people's prompts as well. And so be mindful of that, right? Would you want this to be published? If not, then think about how you frame the question, how you write your prompt, or how you explain things as you use these products and these platforms. So that's kind of my general guidance on the use of AI. I put AI in quotes because AI isn't a new concept, right? Like AI is not novel. I think our current iteration, formulation of it is kind of new and exciting to a lot of people, but AI has actually been around for a long time. People have been building AI for a long time. We've been using AI for a long time. But as we think about kind of the contemporary version of AI and AI models, I would just say if you aren't prepared for it to be published, if you aren't prepared for it to be read aloud in court, if you aren't prepared for it to be on the front page of the newspaper, then probably don't think about how you frame it and how you set it up before you put it into that platform for sure. So we use AI for things that help us be more efficient, but that don't actually, kind of without actually giving away like client intel or confidential information.
Right. So, last question, a little bit more personal outside of work. I know that you're an artist yourself. You mentioned that at the beginning. Shout out to Sound of Heaven Worship,
Art,
right? That's the
artist
group.
is generous,
Oh,
but thank you.
yeah. So I'm just curious, you are an artist, right? And you had that lens and that perspective going into your practice. So how has intellectual property popped up outside of work and outside of your practice?
Yeah,
Um, and how do you think about it right now from a creative's perspective?
yeah. I think it's definitely gotten a lot more complicated, you know. In some respects, I pause, period. I love the fact that artists have the freedom and flexibility that they have now that they or we didn't always have, right? We have flexibility to create, to publish, right? And to really establish reach and an audience without intermediaries or without the traditional intermediaries, because there still are intermediaries, right? The platforms that we publish our work on, those are still intermediaries. They still, it's important to understand their relationship to our IP and our relationship to them, right? So when you record something and you put it on YouTube or you put it on, Apple Music or you put it on whatever platform you publish it on, what are their rights? What are your rights as a creator, as an artist? What are the rights of the people who are going to consume your content? You know, it used to be the case that we had to go to a store and buy an album, and those album sales were tracked, and writers and artists and publishers were compensated based on the number of units they sold and all of that. What does it mean? What do streams mean for you as an artist? What do downloads mean for you as an artist? Do they mean the same thing as album sales? Because they don't, you know. When you download a song on Apple Music, do you own that download or that song, right? In the same way that you owned a record if you went to a store and purchased it? Because I think the answer is no, you don't, right? We don't necessarily think about that, but those are some of the kinds of things that I think about as a lawyer and an artist or creative, if you will. How it's kind of come up for me is making sure, so I'm a worship leader. Most of the music that I do now, pretty much all the music I do now, is through church and in the form of worship leading and creating, singing, teaching, and kind of leading musically at my church. And my church has recorded a few albums that are on all platforms. And so we've gone through the process of one, figuring out how and when we can use other people's music, right? So if you think Sunday morning church service, we have a whole portion of the service where we sing songs. Those songs are not all original. Those songs oftentimes have been recorded and published by other folks, recorded, re-recorded, and we are performing this music live, which generally we are allowed to do, but there are rules around, the fact that we stream our service, right? It is live around the world. People can watch us performing other people's music. What does that mean? What are the rules for that, right? And if we want to put our service up on YouTube or put it up on Facebook, on Meta or whatever other platforms for people to access after service has finished and we're no longer live streaming, what are the rules for that, right? So we've had to navigate those rules and we try to really honor the systems and the process there and do things the right way. So that's been interesting. And then when we record our own original content, our own original music, there's a process around that, right? So if we're writing, who gets kind of authorship credit for that? And then we record. And then, as the video recording is a separate work than the audio recording. And, if we're contributing ideas for a piece, for a work, then how do we kind of reflect that in terms of giving people credit or compensating people or things like that, or making sure that the church actually owns all of it, right? Because it's not sufficient to just own the song, you have to own the recording of the song, right? And so thinking about those things a little bit and making sure that we also have our IP assignment paperwork in place, even as a church, because we want to publish creative works that a whole bunch of people contributed to, right? So it's interesting, and that's kind of the way that it comes up in my personal life most
Yeah.
prominently.
Intellectual property in the corporate boardroom, intellectual property in the courtroom, intellectual property in the church.
In
All
the
right, all
church.
three, you know?
IP everywhere. And I'm not even an IP lawyer, right? So it just goes to show it's just an important part. And there's so many things that I didn't say here, right? That we haven't talked about, and other ways in which, founders want to frame an IP story. And, the IP and the team are really the most valuable assets that a startup has. And so you want to have a story for both. You want to have an IP story, you want to have a story for your team. And hopefully you have a really strong IP story and a really strong team. And then you go on to be something really powerful in the industry.
Absolutely. Hey, Taimur, I personally just want to say I appreciate your time, your mentorship. Um, we met in 20, I believe it was 2016.
Back in the day.
No, 20, no, it was 2018. 2018, back in the day. So yeah, pre the pandemic. And so we're coming up we're coming up on our own, personal tenure, but I just want to say I really, value your time, your perspective. I want to say congratulations on everything that you've accomplished
Thank you.
professionally and also personally, as a father, as a husband, as a church leader. There's so much that I can learn from you, um, even outside of IP. I know you're not an IP attorney in the corporate world generally, but also as a person and as a man. So I really appreciate your time, and thank you so much.
Thank you. I appreciate it, and I appreciate you, and the work that you're doing. Right? It's really important connecting folks and doing what you're doing. And so I appreciate you. I am honored to take the time, honored to be on your platform, and you know, wishing nothing but the best for you and all your clients and everyone who is tuning in.
Appreciate it. I'm gonna drop a link to the worship channel in the description if you don't
I
mind. I'll
don't
do
mind.
that.
I don't mind.
Appreciate
Right
it.
on.